took care of the book.
Thank you, Madam Clerk.
Yeah. We had an elaborate plan as to how he was going to get his notes, and you took care of it. Thank you. All right, call the next case, please.
State of Tennessee versus Tony Brasfield.
Good morning.
Good morning, Your Honors, and may it please the Court. William Gill on behalf of the appellant, Tony Brasfield. At this time, with the Court's permission, I would like to reserve 4 minutes for my rebuttal.
Certainly.
The sole issue in this case is whether Mr. Brasfield established a new residence that he was required to report pursuant to the Sex Offender Registry Act. I believe that the Court will see in the record that there was no evidence that Mr. Brasfield either established a new primary residence in Tennessee or a new secondary residence in Mississippi. And for that reason, we would ask that this Court reverse the judgment of the trial court and set aside Mr. Brasfield's conviction for the charge in count 2 of the indictment. The state's proof in this case consisted almost entirely of GPS data, and that GPS data was testified to by the officer who tracked Mr. Brasfield's compliance with the registry. And based on that GPS data, we have a timeline of the relevant events, which established that on March 9th, 2019, Mr. Brasfield left his home jurisdiction here in Madison County, and he traveled to Lawrenceburg. It is undisputed that he was in Lawrenceburg for 2 days, and then on the second day of his little road trip, on March 11th, he traveled from Lawrenceburg and went to Mississippi. The record is silent as to where he was in Mississippi, how long he was in Mississippi, what he did for the next 10 days. The violation report that was prepared by the officer does indicate that on March 21st, 2019, Mr. Brasfield was in Madison County when he removed his GPS equipment. And that is the relevant timeline that we have based upon the state's proof in this case. Based upon that, Mr. Brasfield was charged in count 2 with violating Tennessee Code Annotated Section 4039-203A1, which provides that an offender must make a report within 48 hours of establishing or changing a primary or secondary residence. At trial, the state's only argument was that Mr. Brasfield had established a new primary residence. Now, the term primary residence is very specifically defined in the Registry Act, and it is defined as a place in this state where the offender resides for at least 5 days, 5 consecutive days.
Counsel, I had a question about the facts. I think you stated something about the record being silent. He was eventually found in Mississippi, correct?
Correct. The officer testified that after the timeline that I just described, at some future unspecified date, he was found in Mississippi. Correct.
Okay, and is it clear when we look at the record, is it clear that that was after March 21st?
I believe so, yes, Your Honor.
Okay.
The officer submitted his report on March 21st, so the same date that he said that Mr. Brasfield removed his GPS equipment in Madison County.
Now, and this is where I've kind of gotten a little confused. The proof that the jury heard didn't say that he was in Madison County when the GPS was removed.
That's correct, Your Honor.
Okay, so.
It was in the report that the jury saw.
Well, maybe. It was redacted out, if I remember correctly.
Correct, Your Honor. It was part of the violation report was, I will say, there was an attempt to redact it.
They put black lines over it.
There was a black line over it. I believe my friend and I agree that even after they put that black line over it, you can still read what's in it. And so in our principal brief, we cited some case law to the effect that when information is decipherable by the jury, it is properly a part of the appellate record, even if it was if there was an attempt to
So if I
redact it.
understand the facts, that, and I know that the testimony was pretty sparse. I think there was just one witness to testify.
Correct, and the sole witness was the officer who tracked Mr. Brasfield's compliance. And we would submit, just to be clear, Your Honor, that if you choose not to look at that report or the redacted portions of it, that the proof is still insufficient. Because in the testimony, all we have is that he left Madison County, his home jurisdiction, on March 9th, and then he went to Lawrenceburg for an unspecified number of days.
And apparently, he had lived in Lawrenceburg before, if I remember.
Correct, Your Honor. His registry documentation reflects that he had a prior address reported in Lawrenceburg. That is
So he
correct.
spends 2 days in Lawrenceburg,
Correct, Your Honor.
then goes somewhere down in Mississippi,
Correct.
then comes back to Madison County on the 21st, because that's when supposedly his GPS was removed.
Well, just to briefly clarify, Your Honor, I don't think that shows that he went back on the 21st. That shows that he was back by the 21st, if you catch my meaning. He could have gone back on March 12th.
Well, I understand that, but we know, but according to, if you read between the lines, the allegation was he removed his GPS on the 21st in Madison County, because that's where I think they charged him with the theft of the device because it couldn't be recovered.
He was not charged with that as a crime. That was, I believe, a basis for revoking his parole.
And his parole was revoked.
Yes, Your Honor.
Okay. And anyway.
I don't know if it was on that basis, just to clarify.
And then he winds up back in Mississippi.
He was found in Mississippi at a later date, correct. And in either case, there was no information about where he was in Mississippi. And then just to kind of complete the picture, his next reported address was a month or two later, and it was Bledsoe Correctional Facility. So all of his subsequent addresses are incarceration-based. And so just based on that timeline, the state argued that he had changed his primary residence. We would submit that the proof is undisputed, however, that again, to change a primary residence, you have to have proof of a place in this state, that's a direct quote from the statute, in this state where the offender resided for 5 consecutive days. And the proof is undisputed that in this case, the only place he was in this state was Lawrenceburg, and he was only there for 2 days. And so the proof is insufficient to show that he established a new primary residence that he was required to report. Now, the state argues that Mr. Brasfield abandoned his residence in Madison County and took up residence in Mississippi. So first, I would say that argument nearly appears to concede that he did not take up a new primary residence in this state as is required. Moreover, to the extent that the state argues that he took up residence in Mississippi, that would be governed by a different provision of the Sex Offender Registry Act. Section 203A3 makes it a crime to fail to timely report a move out of state. And so,
So you're saying A1 is the end state?
correct, Your Honor. A1 uses the term of art primary residence, and that's defined as in this state. A3 makes it a crime to move out of state. And there's a different reporting requirement and a different timeline, which makes sense because if you move out of state, it's less, for example, if someone moves to Alaska, they don't have to report in person. They can call and report that they have moved to Alaska. Now, the state's argument would frankly be a problem for Mr. Brasfield, but for one thing, he was not charged with violating A3. Subsection A3 does not appear in the indictment, and so the state, our position is that the state cannot rely upon something that would be governed by subsection A3 when that was not included in the indictment. He was only charged with subsection A1 in the indictment.
And the count 1 of the indictment was violation of the supervision for life, community supervision for life.
Correct, Your Honor. Because of the terms of his supervision, he was required to seek permission before leaving his home jurisdiction. He did not do that. We don't dispute that
And
conviction.
and that was a misdemeanor, I believe.
Correct, Your Honor.
Okay.
And we don't dispute count 1. The sole focus of our appeal is count 2, which is the felony count. The state's new argument on appeal is that Mr. Brasfield established a new secondary residence in Mississippi. And so that was not its argument at trial. At trial, the sole focus was primary residence. On appeal, the state is arguing that by going to Mississippi, he established a new secondary residence. Unsurprisingly, the term secondary residence also has a very specific definition in the Act. It's a pretty long definition, but really there's only one part of it that's at issue in this case. And that part of that provision indicates that an offender establishes a new secondary residence when the offender routinely resides at a particular place. And it can be an out-of-state address, that is specified in the statute, out-of-state address, routinely resides at an out-of-state address, and in addition, the state must show that the offender was at that address for at least 4 days in a particular calendar month. And unlike primary residence, the secondary residence, the 4 days don't have to be consecutive. And so I think the example that we provided in the brief is like if an offender has a primary residence and maintains that primary residence, but then has a cabin where they go stay on the weekends. And so they're regularly, routinely going to that cabin each weekend or every other weekend or some type of routine like that. And if the state can show at least 4 days in a given month, then that would be a secondary residence that they must report pursuant to the Sex Offender Registry Act, 203A1. Here what we have is the state appears to argue that Mr. Brasfield's new secondary residence was the entire state of Mississippi, because there is no evidence that he went to any particular place in Mississippi. And the proof is well short of showing that he routinely resided at any out-of-state address. And I think this court's case law, there's not too much case law on this, but what we have is instructive. The case of State versus Sykes, which we have both cited in our briefs, you have a situation where the offender went to his mother's house. I believe it was in Mississippi of all places. And so there we would submit you had a reasonable inference that this was, number one, an out-of-state address, a specific place, and it was a place that he routinely visited because it was a place where an immediate family member lived. Conversely, if you look at the case of State versus McGill, which we cited in our reply brief, you have a situation where the state's proof was rather sparse. It indicated that the offender had been to a particular dwelling on 3 separate occasions, had been seen there, and also that he kept possessions there. And this court held that that was insufficient. And we would submit that the proof in this case is even weaker than the proof in McGill that this court found insufficient. All we know here is that Mr. Brasfield went to Mississippi for an unknown number of days. We have no proof that he was in one place, that he was at a particular dwelling, that he was at a particular residence, that it was anywhere that he went routinely. We have provided the plain language definition of the term routinely, and with due respect to my friend, he has no answer for how a single trip to Mississippi, or even possibly a single trip followed by another trip somewhere in Mississippi, is sufficient to prove that Mr. Brasfield routinely resided at any place for the requisite time period.
Well, clarify that for me. It only worked with the second scenario you stated, based on what you argued before, right? That he was in Mississippi, and then you stated he was in Madison County on the 21st.
Correct, Your Honor.
And then back in Mississippi.
He was found in Mississippi at a later date. I believe the implication was that that was when he was arrested.
All right, okay.
And so our position would be that going once or twice sporadically, again, to an entire state is insufficient to show that someone routinely resided at a particular dwelling or a particular out-of-state address. And I think my hypothetical of the cabin sort of illustrates what was contemplated by a secondary residence, a place that the person routinely visits such that the members of the community want to know that that's a place where they could be found on a regular basis. I hope I clarified that.
You did.
I don't have anything further. If the court has no further questions, we would just ask that you reverse the judgment of the trial court and set aside Mr. Brasfield's conviction in count 2 of the indictment. Thank you.
Thank you, Mr. Gill. Morning, General.
Morning, Your Honors. May it please the Court, Kirby May on behalf of the state of Tennessee. Viewed in the light most favorable to the state, we're asking this court to affirm the verdict of the violation of the sex offender registry. I think my friend on the other side and I and the state have a different view of the indictment here and what was alleged in this case. Under the indictment here, the conviction that's being contested, the indictment was specifically knowingly failed to register or report in person within 48 hours of establishing or changing a primary or secondary residence. And that's particularly important because under 4039-203A1, the statute only is the requirement to report within 48 hours of establishing or changing a primary residence. And it's the state's position that under the way this matter was indicted, which is distinguishable from McGill, which the defense relies in its reply brief, where in McGill, that indictment read that that defendant was failing to timely register and register a specific address as a secondary residence. That's not what was indicted here, not what was required by the statute. We're here is...
Let me ask you this.
Yes.
What is the definition of a primary residence?
Well, the primary residence is the place where an individual is 5 consecutive days. And the state's position that he, on March 5th of 2019, now, you also have to have the history of it. The defendant was convicted by guilty plea in 2000 for multiple violent registry offenses. And from 2000 to 2018, routinely and appropriately from the record, again, there's two things. The record consists of the testimony of Officer Rudolph, the probation officer, as well as the record that was introduced without objection except from redactions. That from 2000 to 2018, he reported multiple residents in the previous county where he eventually went to out of, and from there, and that was in Lawrence County. And then in 2018, he changed his primary residence and reported the residence in Madison County. And then on March 5th of 2019, he reported that specific address at 2295 North Highland as his primary residence. That meets the definition of primary residence. And thus, the defendant had established a primary residence in Madison County. And then on March 9th, Officer Rudolph received the TBI GPS monitoring report that showed that the defendant, Mr. Brasfield, had gone to Lawrenceburg, Lawrence County, without reporting it to him.
Okay, that might have been a violation of count 1.
Yes.
But that's not a violation of count 2 yet.
Yeah, because you have to show that the state's position is that he abandoned and changed that primary residence from March.
Let me ask you this. What was the proof that he abandoned?
That he never returned. The state will also dispute the defense position that on March 21st, in his reply brief, the defense argues that he removed the testimony or evidence is that he removed the GPS on March 21st in Madison County. And the state's position, that's not the evidence. The testimony from Agent Rudolph was that he removed the GPS monitoring. And then when you delve into the report specifically says, it simply says that the defendant committed the offense of theft of property on 3/21/19 when he removed the GPS causing a theft from Madison County. It does not say that he returned to Madison County. There's no proof and testimony in the evidence that the defendant ever returned to Madison County.
Well, let me ask you, again, the officer testified at trial that he never went by the defendant's reported residence.
That's correct.
To see whether or not he had left, he had abandoned it. And the statute requires, I think, that he has to be, for primary residence, 5 days, I think is a requirement.
Yes, Your Honor. So the state's position is it's a two-step process. First, as you know, under 4039-202, the defendant has to regularly report and register. And then on a 4039-203A1, he has to report any changes in his residency within 48 hours.
Okay.
And that's what the statute says. Then, so there's a distinction here. The statute and the way this was indicted was that he changed his residence, his primary residence. So the next step would be, once he establishes a new primary or a new secondary, falling within 4039-20212 or 18, Section 18, then he would have to register those new addresses. So
Within 48
he would have to register that he left his primary residence, and he doesn't. And one reason that statute's clear and the language is clear within the statutes, if you also look at 4039-203F, which is in the case and mentioned in the case of connoisseur, where an offender who does not maintain or either a primary or secondary residence shall be considered homeless, and are subject to the registration requirements within the statute. So if you follow the line of logic the defense would want you to, and to its necessary conclusion, a defendant who leaves or abandons their primary residence, which they've reported, like here, as of March 9th of 2019, and never reports, it wouldn't have to report again after leaving that primary residence and changing his primary, abandoning that, until he reported it again. So following that theory to its conclusion, he would never have to report again if he never went to one place and established it, or went to another place as a secondary. That's sort of the argument that if you follow it to the end, you would have to go with. But that's not what the statute requires.
But then again, though, and again, the burden's on the state to prove this. You still have this officer who is monitoring him,
Yes.
never going back to check and see whether he still has this residence in Madison County.
That's,
know?
yeah.
I mean-
That was my question to you. What's the proof of abandonment besides his being gone?
The state's proof would be, and what was presented at trial, is that he left on March 9th, went to the other county where he previously resided.
For 2 days.
For 2 days.
Okay.
And then went to Mississippi. There's nothing in the evidence or proof that shows that he went back to Madison County or to that primary residence. And the state's position is the evidence at trial was that he cut off the GPS monitor, and the violation report simply says, as in any other violation report says, a crime that occurred in Madison, a crime offense in Madison County. It does not say that he cut off the GPS monitor. It clearly says, and it was never recovered. And so the state's position that he never came back. And again, the evidence also in the record from testimony.
Let me stop you here. If he had his GPS on that was cut off on the 21st, then what does the GPS show?
The GPS, there's a dearth of testimony as to the location.
There's not a lot of testimony, period.
Yes, Your
I mean,
Honor.
it's, I think the whole trial transcript is maybe
70, 80 pages.
Yeah, it's,
Yes,
and that
Your Honor.
includes the jury instructions and everything. And I think voir dire. I mean, it's it's thin.
Yes, Your Honor.
But again, you know, the burden's on the state to prove this allegation, and there's specific, and again, the judge charged the jury with the specific definitions, but there's a specific definition for primary residence and secondary residence.
And it's the state's position that the definition goes to what was his primary residence on March 5th of 2019 when he registered. And that was that Madison County address. And that after that, he didn't establish it. And you following the logic of, and the statute of 4039-203 is once he no longer does not maintain either a primary or secondary address, he's considered homeless.
Well, how do you know he's not, that's the question I have, is how do you know he hasn't maintained his primary residence?
Because
Because he's traveling, he's driving around?
Because after that point, he's eventually, again, the dearth of testimony, he was caught in Mississippi. That's the testimony.
And we don't really know where I mean, the record doesn't say where he was caught in Mississippi.
No, it does not, Your Honor. Say we'll concede that. And that from there, the next time he reports, again, he never reported again after March 5th of 2019. The next time he was required to report was when he was in custody in Bledsoe County on April 12th, over 30 days later. And the state's position is the intent, part of the abandonment intent is, one, he went to Lawrenceburg, went to Mississippi, and cut off his GPS monitoring. That shows the intent that he abandoned his primary residence. And the state would argue that, looking the light most favorable to the state, that this court should affirm that.
The only problem I have, I guess, is this issue about cutting off his GPS. Was there testimony to that, or is it just in that redacted?
No, the record will speak for itself. I'm fairly confident that the officer did testify around, let's see, I think around page 52 and 56. I believe, the record will speak for itself. I think that was where there was discussion about the GPS monitor. But it is definitely in the exhibit, I think it's number 3, about that. Again, it's very brief. But the state viewed in light most favorable to the state the evidence presented to the court, to the trial court and the jury, that this court should affirm the conviction of the violation of sex offender registry.
Will you briefly address the A3 versus A1 argument he brought
Of the A3, so A3, again, this was not indicted. So yes, it is an alternative theory. Yes, could the state have presented that as an alternative theory? And would that have been a viable alternative theory? Yes, but the state went under A1. So A3, you have 4039-203A3, which is a requirement within 48 hours of intending to move out of state. And then you actually have, and I think the defense also mentioned, there's actually 4039-208A9, which also fails to report when moving out of state. But again, the state's position is those are viable alternative theories they could have indicted, yes. However, we're looking at the sufficiency of the evidence that was presented and the indictment that was presented at trial. And
Which is under,
4039-203A1.
right, okay.
That's what the jury heard, right?
That is what the
A1.
jury heard.
Okay.
Thank you. If you have any other further questions, thank you for your time.
Thank you, General. All right, Mr. Gill.
Thank you, Your Honors. I'll just briefly address a couple of points and answer any further questions that the panel may have. First of all, I would say I believe when you look at these provisions, the statute contemplates that a person has one primary residence at a time, and that you may abandon that primary residence either by establishing a new primary residence, that would be changing a primary residence, or by becoming homeless, in which case there are statutory provisions that would address that. Those statutory provisions were not charged in this case. You may abandon your primary residence by moving out of state, either into a new residence or becoming homeless in the new state. There is a provision for that. A3, it was not charged. And so what we have here is only what was charged, what was instructed to the jury. Changing a primary residence by establishing a new primary residence. And Judge Campbell, I must respectfully follow up on your question about the definition. My friend said that means 5 consecutive days. It also says in this state. That's a direct quote from the statute. Again, the proof is undisputed here that the only place that Mr. Brasfield was in this state was Lawrenceburg, and he was only there for 2 days.
Let me ask you this. This cutting off the GPS,
Yes, Your Honor.
the state's argument is that shows his intent to abandon and go off the grid or whatever it is, or to leave his residence and basically go someplace else. What is your response to that?
Number one, just as a factual matter, I don't believe that there was any testimony about removing the GPS device. I believe that only comes from the report. It does say in the report that he...
If you can read under the scratch marks.
Yes, you have to apply some scrutiny to this ostensibly a redacted portion of the text. And it says that he, by removing his GPS equipment, he committed the offense of theft of property, and that occurred, quote, in Madison County. Now, I understand the state's position that maybe that was some kind of boilerplate that doesn't really mean what it says. I'm just going by what it says. And so
Well, what was the actual testimony? Because I kept trying to remember whether I heard or saw in the testimony that the GPS had been cut off.
I do not believe so, Your Honor. I do not believe that appears at all in testimony. I believe the only time GPS is mentioned in the testimony is when the officer indicates that that's how he tracked Mr. Brasfield's movements.
To Lawrenceburg.
To Lawrenceburg and then into Mississippi.
But then at some point, it just, apparently there's no other data about where he goes to Mississippi.
On March 21st, there is no data. There should have been data about he had his GPS device on the entire time between the time he left on March 9th and when this report was submitted on March 21st. He had his GPS device affixed the whole time, but there was just no proof. The state for whatever reason, did not supply any proof about where he was in Mississippi, even though it ostensibly had that proof based on the way that I understand GPS works. And so I have no explanation for why that evidence was not supplied. It just was not supplied. I have tried to be as upfront as possible about where I'm getting this information about what happened when he removed the GPS. What I would assert, Your Honor, is that alone, the fact that he removed his GPS, again, it says in Madison County, is not sufficient to show that he abandoned his residence. And I think it's very important that there is no crime charged of abandoning one's primary residence. The crime that is charged is establishing a new primary residence or changing a primary residence, which can occur by establishing a new primary residence.
Right, so the indictment only covered A1, is that correct?
Correct, Your Honor. A1 in count 2, which is the only
Right.
count that we're
Count
talking about.
one
Is
is a different story.
undisputed,
Yeah.
correct, Your Honor. I
Okay.
see my time is up, so if there are any further questions, I'd be happy to answer them. Otherwise, I'll just close by asking that this court reverse and set aside the conviction in count 2. Thank you.
All right, thank you, Mr. Gill. As in the previous case, the briefs were excellently written and presented in this case, too. We appreciate that. We'll take it under advisement.